So the first speaker is me. So I will stop my sharing for 1 second while I bring up my other presentation. And I will also bring Paul on as a panelist. Hopefully that will go smoothly. Okay, great. Hi there, Paul. Thank you for joining us. And so now I just need to get the Zoom things out of the way so I can go to slideshow mode. Great. So let's get cracking. So I've got a lot of content here. I uploaded all the slides. So actually you can see all of the slides of everyone's sessions already on the event page. So if you want to follow along for accessibility reasons or for anything else, then please do go and have a look at the event page on the IPTC website. But I realized that I had way too much content for this because I'm only supposed to be talking for 15 minutes. And so I've removed many slides, but you can go and have a look at them on the website.
Brendan, you can borrow 3 or 4 minutes from me because I'm coming in about 6 to 8 minutes from mine. So.
Well, we'll try and leave some time for Q&A.
Okay.
So I think let's see how we go. So AI and opt-out. So I'm not going to go into any information on why AI opt-out might be interesting for people. I think that's pretty obvious that content owners and rights holders are very interested in protecting their rights and conveying when they want to opt out from AI training, but also when they want to opt in to AI training. So we do have members who are very interested in making sure that their content is crawled and used as training data for engines because they want to get the content out there. So we want to be able to express both of those. But the trouble is there are many different ways to do it. So which one should a publisher choose? Which solutions work for different media, for images or video or text or web pages? It's not very clear. How should third-party content be handled? For example, images from wire services. So PolsX Getty Images is a classic use case that a publisher might host an image that they actually don't own. They own a license to publish that image, but it's actually owned by someone like Getty Images. Many other image libraries and news agencies exist. And but how should they specify whether that content can or cannot be used for training data? So just something like a robots.txt file at the top level of your website is a bit too blunt of an instrument for some of these use cases. Are there steps that publishers need to undergo different in different jurisdictions? So in the EU versus the US versus Asia, there are different rules around whether AI engines have an automatic or whether publishers have an automatic opt-in or opt-out in terms of expressing their rights. How does this content work, not just with crawling and training, but with agentic AI, where the AI is actually going to your website in order to answer a user's question? And RAG is another variation of that, the retrieval augmented generation, I think it stands for, and an AI search summaries on the top of Google search results page. How do these opt-out instructions work when the crawling and the training are actually two separate activities that are undertaken by two separate entities? So there's famous crawler systems like Common Crawl and one called Leon that specialize in just crawling the web and providing resources that AI engines and others can use. And so respecting some directives at the crawl time might not be the right thing to do, because it might be that it's available for some people to use but not others to use. And so how should all of that be expressed? and which of all of these solutions are actually respected by AI providers today. So in summary, are there any simple steps that we can recommend to publishers in terms of what they should do to have the best chance of having their wishes respected in terms of whether or not their content will be crawled? So I'll just take a very swift survey of some of the different approaches that can be used using today's technology, first of all. So the most common approach is robots.txt. So probably most of you know what that is. It's a file that you can put on your web server. It's literally just your domain / robots.txt. And this is what it looks like. So you have a series of directives with a user agent name, which could be a star for just any user agent, or you can name a user agent explicitly. And then a series of allow and disallow statements that tell that particular user agent, that particular robot crawler, what it is allowed and not allowed to access. And these are not legally enforceable right now, but they express your wishes and hopefully align with things like copyright and usage licenses that maybe can be enforced. But obviously, that's another question that maybe Paul will be going into. So at the moment, there is no way that you can specify in a robots.txt file all AI robots are not allowed to see my content. You would either have to just use a star and ban anyone from accessing your content, including search engines, for example, which probably you don't want to do, or you have to list each crawler robot separately with its user agent string and then have the allow and disallow commands. And that's obviously not scalable because there are hundreds of these things out there. There are new ones every day. They change their name sometimes. So even if you do block a particular agent, then it might be called something else tomorrow. And so that block may no longer work. There's another protocol called the TDM, Text and Data Mining Reservation Protocol, that was made by a World Wide Web consortium, W3C community group. So it stresses not a W3C standard, but it's a report from a W3C community group. And it takes a similar approach. It's a file that lives at the top level of your web domain, but it expresses explicitly whether content can be crawled or not. So the way they express it is a text and data mining reservation because it follows the language that's used in the EU Copyright Act. And so you can use this file, or you can also use HTTP headers or meta tags in your web pages. Not going to go into what those mean. You can look at our guidance. And you can actually express either yes, no, or yes with policy, with a particular policy. And the policy actually uses ODRL, which is we have an IPTC standard called Rights ML that's based on ODRL. And so it allows you to express quite complex rights statements. But as far as we know, no AI engines are parsing the policies, but apparently some are now looking at the TDM rep file and they do actually respect the yes or no reservation tags. So we have a horse in this race as well. So there's a embedded metadata property that we just call data mining. And there's a vocabulary that we've created in association with Plus, the organization that David is aligned with. And it allows rights holders to express within the image itself whether or not it can be used for AI or ML training. So that's something that we like because it solves that Getty Images problem that we were talking about earlier, that the publisher of the content might not be the owner of the content. So ideally, the image will still have the metadata embedded, even when it's on someone else's site. So the crawler will respect that, should respect that. There's another one that's in the C2PA universe. So there's a aligned organization called CAWG, C-A-W-G, that I'll be talking about later. And they have an assertion that can be used in C2PA signed content around whether AI training is allowed or not allowed or constrained. with a text field. So that's out there as well. You can use firewalls to block bots at the network level so they can't get to your content in the first place. That is a popular approach, but it has the same problem that you have to block bots either by name or by IP address, which is also not very scalable. But it does have the advantage that you don't have to rely on the bots to honor your robots.txt or TDM rep files. You don't let them see. It's a bouncer at the door of your website saying you can't get in. Some people have taken these approaches and created commercial tools around them. So one is called darkvisitors.com that has a service that updates your robots.txt file for you when a new bot comes out. And then Cloudflare, the large company that's used as a content delivery network and other things for many sites around the world, has a mode called bot fight mode, where you can just select an option and AI bots will be blocked. And as of July this year, 2 months ago, that is now switched on by default. And so the bots have no choice, and they maintain this list of robots and IP addresses for you, but you have to pay them for it, obviously. There are other systems out there that offer services where they will redirect the robots to a site where the AI engine can buy a license to index your content. So those are growing now. I won't go into the details. You can look at the slides. So to summarize what's available there, I think I've gone through most of it, but the TDM reservation protocol, it works for any type of content, but it's not very well implemented across the industry yet. Again, the IPTC and plus data mining property that is in embedded metadata is also not widely implemented yet. Data mining assertion, same story. There's not a whole lot of CGPA signed content, let alone CGPA signed content that contains this particular assertion. Robots.txt, I think I talked pretty well about the limitations there. Some of the AI providers have a form on their website where you can say, please don't train on my content, but with some of them you have to put in individual URLs of every single image that you own. So that's, again, not scalable. And the firewalls is most effective, but it's a huge effort to maintain the database. So we took all of those as the existing mechanisms that are out there and created a set of guidelines, best practices that publishers can follow. So it's definitely not the answer for all of this, because it really just takes all of these solutions that are not perfect and just tells people how they can implement them the best way that they can. But hopefully we'll be able to do new versions of these guidelines as things become a bit easier in terms of implementing the approaches. So I forget whether I took out the, I can skip over these. These are the actual guidelines, which really just go through each of those approaches and tell publishers exactly how they should do it. But you can look at the document for that. So now I'd like to talk about, just for a couple of minutes, some work that's going on right now in a working group of the IETF, the Internet Engineering Task Force, that is responsible for the specs that govern a lot of plumbing of the internet. So they write the spec for email, for HTTP, for HTTPS. And they have a working group that's looking at evolving the robots.txt specification, a thing called the robots exclusion protocol, to account for AI crawlers. And so there have been meetings. I was at one in London in July. There'll be one in Zurich in 2 weeks' time, which I'll be attending virtually. But there's been wide representation from across the industry, people from Google, people from Microsoft, OpenAI, even the AI engines are involved, and a few people from the content industry. But it would be good to get more representation if anyone is interested. Anyone can join. So there'll be some links in the slides for how you can join in if you're interested. So what they're doing is they've separated the vocabulary of how to express your requirements, your preferences around AI training, versus how to associate those preferences with the content. And so they're calling them the vocabulary and the attachment specs. And the idea is that they will become two different RFCs. For those of you who know what an RFC is, a spec document released by the IETF. And so there is heated discussion going on right now around how those documents will work. They want to publish something in the next couple of months, but there isn't really much agreement yet. But the current understanding in the current draft is that there'll be a hierarchy of the declaration of what you can and can't do with a particular piece of content. And the idea is to have a hierarchy where the overall category is called automated processing. It used to be called text and data mining, but we wanted to make it a bit more generic. And then within that, there's AI training. And then within that, there's generative AI training. And then there's a separate category called search, which relates to, it maps to our plus data mining vocabulary term around making sure that your content is available for search, but not available for generative AI training. We wanted to be explicit about saying we don't want to throw out the baby with the bathwater and say you can't do any training on this, and so therefore exclude search. But of course, there are issues around that because search and AI are blurring now with these AI summaries at the top of search results. So what does it mean to allow search and not allow AI? So there's a lot of discussions going on around that type of topic. So the idea, again, using the current spec as a reference, which is not final by any means, but the idea would be you would add something to the robots.txt file around content usage. So the user agents can look at this content, but then once they look at it, what can they do with it? Can they train their AI with it? Can they use it for search purposes? So that's the idea. It could be either in the robots.txt or in an HTTP server response, which is again the way that robots exclusion protocol works now. We are pushing to get embedded metadata referenced in this attachment document as well. There is a reference to it, but there's a rule within IETF that they can only reference their own standards. So because XMP and IPTC photo metadata are not IETF standards, then they can't specifically reference it, but they can talk about how there are existing embedded metadata protocols and standards out there. So stay tuned. I think this is our best hope right now. So yeah, they've put the drafts in what they call working group last call state, but really that's just to focus the conversation and work out exactly what problems people have with the current version of the spec. And so hopefully there'll be something published. And then a curveball came in just last week that says that that is a new standard that's been released last week by Reddit and Yahoo and Medium and some others. It's got names like Tim O'Reilly behind it, which is quite interesting. And it's called Really Simple Licensing, RSL. And they say that it's sort of the equivalent of RSS for licensing, which sounds interesting. And for those of you who remember RSS, the simple XML format for content syndication. So maybe there's something to it. I've only really just started looking into it. They actually also have a thing called the RSL Collective, like a rights collection agency that you can join, and then they offer to collect royalties on your behalf and then distribute them to the members. I'm not really sure how that would work in reality, but it's a really interesting idea, and it does have some big names behind it. So I'm hoping to get some more information on how that's going to work, and maybe you'll be hearing more about that in a future session. So that's all I've got for my session. So now we can move on to David, who'll be talking about the proposed generative AI properties.
Okay.
And we'll do Q&A at the end. Hopefully we'll have some time.
Let's see if this works. Oh. Okay. Just seeing the slides.
Yes, we do.
Okay, great. Um, Hello, I'm David Ricks. I'm the current lead of the IPTC Photo Metadata Working Group, and I've been volunteering with the group since 2004. Today, I wanted to share with you our proposal for a set of new properties that the IPTC will be voting on in a month or so, and give you a peek behind the curtain about how our working group develops open standards. By the way, that's Alice on the microwave in her Sphinx mode, and she wants you to know that she was not generated by AI and refuses to live in a post-truth society. We've been working, actually we'd had one of our IPTC members had first suggested this idea about having some fields to record generative AI properties. Dennis is with Glide Publishing Platform, a content management system, and was looking for a way to help his users record those details, specifically those created with artificial intelligence. So why is this needed? Well, it's not necessarily because we're fans of generative AI art, but more because this is a way to ensure that others won't confuse these images with real life. We had already included some recommendations in our IPTC photo metadata user guide for recording metadata for AI images. And just like with other, you can download the slide deck and it'll have all these links in it, so you don't have to write those down. These recommendations were to leave the image creator field empty because the system is creating it. And instead use the contributor property, which includes a name, optional identifier, and a role attribute, and also to give it the digital source type tag of created using generative AI. And after we had some we had initial conversation with Dennis about particular use cases, but we decided we wanted to see if there was anything else that was needed and did some investigating. So we started with Dennis's use cases and then added to those, and we tried to compress those down to about a dozen, although looking back at them now, some seem kind of similar, but they each have little different tweaks to them. I'm not going to read through each of these, so you can read through those at your leisure, but you can scan the list. I'll paint a couple of scenarios. What if you're in charge of providing supplementary images for a regular column and you're taking over for someone who has left the company? Well, if you knew which service that they'd used to create the image and you knew what the prompt was for that particular image, that might help you get a similar result with a little less trial and error, we would hope. Given all the recent lawsuits, I can envision a time where there might be some kind of global cease and desist order from using any images created with a specific AI system or even a specific version. So how would you go about doing that? If you use this and you've got a tag tied to the image that told you which system was used, then should save you a lot of time. And since, I'm a novice at generative AI. I've only used a few systems, so we decided to take a look into a number of the more popular generative AI systems. Again, looking mostly at those that are free or didn't have some onerous registration requirements. But we got to see what users are being asked to enter most frequently, and then attempted to group those by function. You can see here are a few of the example screen user interfaces we looked at: Bing, Shutterstock, Firefly, Flux, Crayon, others, I think about 30 other systems, something like that. So it was kind of an open survey. There are some of the fields that we initially listed that seem to cover most of the elements in our use cases. Some of those had to do with knowing what the prompt was and who created the prompt, as that could be helpful if you need to create a new image that needs to fit in with a continuing series. For those instances where people are uploading images to use for inference, I thought that might be good to have some way to record that image after the fact, though there was a lot of discussion about how to record that. Should it be a URL, a path, a file name, any of those, all of those? So that's still under consideration. We'd also thought it might be helpful to know if any work had been done to the image after AI generation. So thought a field to capture some of those actions could be useful as well. However, from continued discussions, it seemed that this option might be something that could also be useful for non-generative AI art images as well. So it's something to consider for the future, but not specifically something needed for recording details about an image created with generative AI. Since generative AI is so new and things are changing pretty rapidly, we thought it would be good to share our proposal with a wider audience. And we put out a request for proposal or request for comment. So keep in mind, DALL-E, at least from what I recall, was released in January of 2021. ChatGPT arrived in November of 2022. So it's only been a couple of years. We took what we thought were the most useful of these, sketched in some technical details, and then put out this request for comment this summer. We got a number of useful suggestions, which we did incorporate, and then we settled on the following 4 properties for this fall's proposal. So here are 2 of the 4 fields. I'll show the other 2 in the next screen. These are what we're proposing to add to the 2025 IPTC photo metadata standard. That'll be, again, voted on in about a month. These first 2 identify the AI system and or model being used, as well as a version number, if known. Having these values should make it possible to locate an image made with that specific generative AI system later on. The following 2 fields can be used to store the details of what was in the original prompt, as well as who wrote that prompt. So if you're trying to replicate a specific look or feel, starting with a very similar prompt might help you get the result you're after. As the user note states, prompts may include both positive or negative prompts. So you could have something like rainy street scene without pedestrians, or futuristic city skyline bathed in a warm golden glow without any clouds. So, but whatever you composed as your prompt, even if you're doing it iterations, if you can combine that all together into one long prompt, then you can store it with the image. And yes, we are aware that there's no guarantee that using the same prompt in a newer system or even the same system is going to give you the exact same results, but it's more likely to get you in the ballpark than if all you have to work with is just looking at the image itself. And it might help to be able to contact the person who did this work. So if so, knowing the name of that person could help, especially if they're still around in your company. These specific fields are likely going to be something that's more useful within an organization or company. And yes, I know that some people keep their very involved prompts close to the vest, so they may not be interested in giving you everything. But for those who do want to share or simply have trouble keeping track of what they had asked for before, this should be a really good starting point. So that's all I have for you in this segment. Just a quick note of thanks to our many regulars and semi-regulars that have helped contribute to this standard. And I've got a last slide on here with a page of links that should be helpful if you're trying to find some of our other resources. And that's all I've got. Stop
Great.
share.
Thank you, David. So now we can move on to Paul, and we should have some time for Q&A at the end for all 3 of us. So take it away, Paul, when you're ready.
Great, thanks. Hold on, let me share my screen. Okay. I think you should be able to see that.
Yes, we can.
Okay, great. Well, thank you, Brendan and David. I think that was a really good setup for what I'm going to talk about. So my name is Paul Reinitz. I am a JD MBA, and I'm an independent business consultant based in Seattle. I work with technology and media companies on AI governance and intellectual property strategy. Previously, I served as AI counsel at Getty Images, as Brendan said, where I worked on AI policy and product development, including the EU AI Act compliance and IPTC metadata implementation. My role also involved helping to craft litigation strategy and to develop frameworks for AI training and data governance. Today, I'll share some insights from both the legal and business sides on how copyright metadata and generative AI are converging and what that means for creative visual work. So I think this plays really well to what David and Brendan were talking about, because it's kind of two sides. In that right now, media professionals find themselves at a media crossroads. So generative AI has fundamentally changed the landscape. And it's created both opportunities and challenges that didn't exist just a few years ago. On one side of this crossroads, professionals want to leverage copyright to protect their existing work from being used unfairly as training data. This is about preserving the value of creative output and maintaining control over how it's used, sort of the basics of copyright. Now, on the other side, these same professionals want to harness the power of generative AI tools as part of their creative process. And they want to do it safely, and they want to be able to commercialize the work that they create with AI assistance. And this isn't an either or situation. So visual media professionals need to navigate both sides of this crossroads successfully. And the challenge really is doing both things well, protecting your existing rights while embracing new AI-powered workflows. And this crossroads doesn't exist in a vacuum. Copyright law is struggling to catch up to this new paradigm. And I'll walk through at a high level over the next few slides. There's active litigation and regulatory action that visual creators need to understand and navigate. So first, let's talk a little bit about copyright litigation. So generative AI has been a hot topic in the copyright community over the last few years. There's significant legal uncertainty, which has led to quite a bit of litigation. As you can see here, there are 22 active federal US copyright suits working their way through the courts. And as this word cloud illustrates, pretty much every major developer of AI models has been named as a defendant. In almost all of these cases, fair use is central to the defense, which involves the litigation of the 4 fair use factors, which I'm not going to go into all of that right now. That would be a whole other presentation. So most major cases are still mired in discovery and procedural motions, but we've gotten some early decisions which have been mixed in what the courts have found. So Thomson Reuters scored an early win with the court finding that their use was protected as training data was not sufficiently transformative and it wasn't commercial in nature. However, on the flip side of that, in the first cases out of the Northern District of California and against Meta and Anthropic, courts found that training generative AI models on copyrighted work was, quote, spectacularly transformative. Now, it wasn't a complete win for the tech companies, because even though their use of that work was considered to be a permissible fair use, the use of work sourced from databases of pirated books was still found infringing. And so that's really important. Where you source your data is critical. And based on that liability alone, in the Anthropic case, they reached a proposed $1.5 billion settlement with the book authors. It hasn't been approved yet, but that really gives us a window into what's at stake on the litigation. Now, going forward, my guess is that cases will likely turn on how courts handle the 4th fair use factor, and that's the effect of the use upon the potential market for or the value of the copyrighted work. That said, each case is very fact sensitive, making it difficult to predict legal precedent with certainty. The takeaway here, because of legal uncertainty, there's a strong incentive for AI developers to source data from legitimate sources and license copyright work when needed. Okay, so on top of that, there's a regulatory framework that is evolving. I'm not going to go through this entire slide, but you should know that really the EU and the US is really the most relevant for visual creators. First, and Brendan touched on this a little bit as well, the EU Copyright Directive, which was actually enacted way back in 2019, which seems a long time ago in the context of generative AI. At the time, the media really focused on other provisions, but the text and data mining exception in Article 4 may be the most relevant for creators who don't want their work used for AI training. It basically creates a mechanism where copyright owners need to proactively opt out of the exception. If they don't do that, the law is that their work can be mined and used for training without any authorization. Now, another key piece of European legislation is the EU AI Act, and that went into effect recently in August. It's a complex piece of legislation that addresses a wide range of issues, but most relevant to copyright are the transparency provisions in Article 53. And that requires developers of general purpose AI models, or GPAI models, to follow a few things. Quick summary: the Act references the text and data mining exception that Brendan and I just talked about, and reiterates that opt-outs must be respected. So it's putting some more teeth into the law there, at least in Europe. It also requires GPAI providers to retain summaries of content used for training and to design systems to prevent infringing content, label AI generative content, all of which are good news for creators, at least in my opinion. In the US, federal AI legislation has mostly stalled. There's a couple things going on, but the only firm guidance that we've gotten is from the US Copyright Office, which basically says if you're going to use AI, you need to disclose it if you want to register your copyright. States have been picking up the slack a little bit from the federal government, and almost all the states have enacted some sort of AI legislation. Again, I'm not going to go into details. You can look those up. But what's emerging across there is that there is a trend of prioritizing disclosure and transparency as core principles. Now, what's emerging across all these frameworks is a clear emphasis on transparency. This is where metadata standards like IPTC become not just best practice, but a compliance strategy that meets the broad regulatory push for transparency, and it works across multiple jurisdictions. Okay, so as many in this audience know well, over the last few years, IPTC, and let's also talk about C2PA standards, have provided the groundwork for implementing a comprehensive AI transparency strategy. I know, as Brendan said, this is evolving, but if you stay with the evolution, it is a good strategy. Right now, you can use metadata to indicate AI opt-out preferences for your existing work. You can identify when content has been AI generated or manipulated. And then you can also enable provenance verification through the content lifecycle, and that's using C2PA. Now, the key insight here is that the same metadata infrastructure can address multiple regulatory requirements all at the same time. Whether you're dealing with EU opt-out requirements, US disclosure mandates, or state transparency laws, consistent metadata implementation gives you a foundation that really scales across jurisdictions. Okay, so I've organized these protection tools and strategies into 3 categories, and Brendan did touch on a bunch of this, so I'm going to go quickly. And remember, these are just some examples of what's possible. First, and this is a bit of speaking to the choir here, I know, leverage metadata standards. This should be your foundation. Preserve metadata as a rule and embrace transparency requirements. Get comfortable with signing content using C2PA. And if you need some help getting started, IPTC has published a great guide on this that I'd recommend checking out. Second, you want to develop a strategy related to unauthorized scraping and licensing. Brendan, again, also talked a bit about this. But remember that indicating you do not want your content used for AI training is not just a nice to have. As we talked about before, it is a requirement if you want to opt out of the EU text and data mining exception. Well, I'm not going to go into the details, and Brendan talked about it, but that resource about the 12 technical suggestions is a really good one. It is a really good quick guide, and it covers all of the things that Brendan just talked about. Now, finally, in addition to taking steps to opt out of unauthorized training, you may actually want to license your work. Now, many organizations have done this, and they've entered into direct licenses with AI model developers. And there are emerging standards for automated license. Brendan did just talk about RSL, which I think is a really interesting concept, and it seems like it looks pretty promising, and those early adopters I think are very important. Now third, you want to make sure that your technical and legal solutions are consistent. This is critical. You make sure that your compliance and technical teams are working together. Your most elegant technical solution won't help if it's inconsistent with a written agreement, like your website terms, privacy policy, or licensing agreements. Okay, so now let's flip the script a little bit. We talked about protecting your existing work, but what about when you want to use generative AI tools responsively in your own creative workflows? This is that other side of that crossroads that I brought up. The key framework here, again, is transparency, but the level and type of transparency really depends on the context. But first, default to transparency. Disclose AI generative content and the tools you use for creation or edits. Be honest about your content sources. This isn't just good practice. It's increasingly a requirement, for instance, if you want to get copyright protection in the US. Second, think about the context. Editorial use requires the highest standards. Your workflow may even require that you verify factually accuracy of content independently. And you also want to consider using C2PA credentials for newsworthy images. While it may make sense to treat creative content with less rigor, it's always best practice to be transparent about the commercial use of generative AI. Third, and I think this is important as we're trying to figure out what tools we want to use, is that you want to demand transparency from your AI tools. Use commercially safe generative models. And one good rule of thumb is use GPAI tools from developers who've agreed to the EU Code of Practice. This isn't just about compliance. It's about increasing the chance that your opt-outs will be respected and reducing your liability risk. Now, this brings us to a couple of broader industry trends that are making transparency not just practice, but actually a competitive advantage. So look at what's happening in the AI industry. I think this is a good illustration. So major general purpose AI models, and that, again, that term is from the EU AI Act, they've agreed to the voluntary commitments under the EU AI Act Code of Practice. Google, Microsoft, and OpenAI are all implementing both C2PA standards and the EU code requirements. What does that mean? These companies are committing to respect opt-outs and to develop systems for conveying transparency and provenance. This is a significant win for IPTC and C2PA standards and other evolving metadata standards. When the biggest AI companies voluntarily adopt these transparency frameworks, it validates that metadata-based approaches are the right technical foundation. And that brings us back to the crossroads we started with. Adopting IPTC metadata standards helps you with both sides, protecting your existing work through machine-readable opt-outs and enabling trusted distribution of AI-generated content through provenance tracking. For creators, this means betting on IPTC and C2PA standards isn't just compliance. It's about aligning with where the industry is moving. So I think that's about all the time I have today. I hope that this overview of the legal landscape and practical strategies has been helpful as you navigate this visual media crossroads. Remember, the key takeaway is that transparency and rights respect aren't just compliance requirements. They're competitive advantages. The metadata standards you already know and use are becoming the foundation for both protecting your existing work and enabling trusted AI-powered workflows. I'd love to continue these conversations, and you can reach me at the email here. My slides are also up on the site. And I'm always interested in hearing how you're implementing these approaches in your own organizations and what challenges you're facing. Thanks, and I think we probably have a little bit of time left for discussion.
Thanks very much, Paul. That was really good. So we have 2 questions in the Q&A. So I'll just go through both of them. I think we can manage that. So they're both from anonymous attendees. I'm not sure whether that's deliberate or it's just how the system works. So the first one, can you highlight the difference here for different types of media, i.e. audio, video, still, interactive, 360 or photogrammetry type projects, and how you presented and how what you presented can be utilized to cover considering the difference in IPTC use in all? So I guess that's talking about like how you can attach the opt-out information to different types of media. So I think from the IPTC point of view, IPTC photo metadata can be attached using XMP, which is a standard created by Adobe, but is now an ISO standard, and it works with many, many different media formats. And so pretty much any image format, except for raw images, by definition, you can't attach any metadata to a raw image. But yeah, any image format will allow for XMP, including our data mining property, and for that matter, the digital source type, which allows you to signal when something was AI created. So yeah, I think that's maybe the simple answer for that question. Maybe if there's a more nuanced question you'd like to ask, you can ask something again in the Q&A. David, Paul, do you have anything to add to that?
The only thing I'd add is that we'll be talking about in the next session, the Adobe Custom Metadata panel can be used to tag images with a lot of these newer fields, even though you may not see them in Photoshop and things like that. We've now got the full IPTC schedule. So if you want to add digital source type or other data mining, things like that, you can do that with Adobe Bridge or a bunch of other Adobe products.
Great.
I could add quickly that, and I didn't really bring this up in my presentation, but under the text and data mining exception in the EU, you don't actually have to have metadata opt out. Like, so you could use what the legislation actually says, machine readable, right? And so many companies have interpreted that to read, you can put it in your terms of use, right? Your terms of service. And that's expected to be readable. And you could go into more detail than it's available in metadata standards about how you want your things to be used. And if you want the audio to be handled differently than the visuals, then you could write that into your terms. Will it be respected entirely? I don't know, but it's one strategy as this stuff continues to evolve.
So the theory is that if the AI engines are so smart, then they should be able to parse the human readable terms and conditions, and what is human readable is now machine readable because the
exactly,
machine.
Yeah.
Great. So we have another question. Maybe I'll go for this one. How would the landscape change if the US courts determine that the training per se is fair use, all other issues aside?
Yeah, so I can hit on that again, and I know I really kind of went over this very quickly in my presentation. But to look at these, they are really done on a case-by-case analysis of looking at not just one of the 4 use factors, but all 4. And they need to look at the factual context. So even if you get 5 cases that say it was fair use, that doesn't necessarily mean that the next 5 cases are going to be fair use. I think there's going to be legal uncertainty as long as we're relying on a fair use analysis to figure this out. There may be legislation that comes in and trumps that. I don't see that happening, anytime soon. But I think the takeaway is that it's very, very difficult to predict these fair use cases.
Well, and also fair use is something pretty central to the US, but I don't think I don't think there's any other country that have, well, there's some that probably have similar concepts, but I don't think it's handled the same way.
That's absolutely right. The UK has something called fair dealing, but and also in the EU, when you're talking about the text and data mining exception, that kind of throws away any concept of fair use, because it basically says this is fine unless someone says you can't do it. But as I said in my presentation, I do think that the 4th fair use factor is really important, and thinking about how the use of that content for training the model impacts the market for that content. And so, for example, like if you could think about, like, you're training a generative AI model that's supposed to generate audio just on copyright protected audio recordings. And then the purpose of that model is to basically create audio recordings. It's kind of hard to argue that that's not going to impact the market for those underlying recordings.
Great. Okay, well, thanks very much. We're right on time at the end of that session. So there's one question still in the Q&A, but maybe we can answer that in typing during the next session, which is about to begin. So I will, if I share my screen, I don't see the Zoom things. So Paul, I'll put you back to an attendee. Thanks very much.
Thank you. Thanks for having me,
For
Brendan.
a while. Thank you.